last year, to the concern probably of many in this room, the state took the structure of the commission that's charged with policing, for lack of a better word, judges in the state, and took that structure out of the Constitution where it's been set for a number of years, and said that from now on the General Assembly would determine that structure. And whether that was, we can debate, as many did, whether that was a good or bad decision and the reasons for it. But we're not going to try and redo that debate here. What we would like you to address, if you would, is where do we go from here with the JQC? Now that the General Assembly has the ability and is going to determine how it's structured and operates, what's that going to look like, particularly with respect to transparency? What sort of window, if any, will the public have into its process?
Well, thank you, Peter. First of all, it's great to be here. It's quite an honor to be asked to attend the meeting with you. The skyline of Atlanta is very beautiful at 7 o'clock in the morning. I don't do that very often. So it's nice to have that opportunity. Let me talk about the ongoing situation last year with the issues about the JQC. And believe me, I did not enjoy it with any glee into that arena to battle about it. But I had a understanding from a lot of information come to me that there were things happening there that just were not in the best interest of the state or our judiciary. And with those facts brought to me, I felt something had to be done. You had to realize this was the only autonomous agency of any kind that we had in the state of Georgia. When I say autonomous, it was created within the Constitution, and no one had any oversight as to how it's managed, the processes it went through, et cetera. So for many years, it operated very quietly and efficiently, we'll say, doing its work. I think the last several years, things went astray as far as the road they were traveling, and I just had to look at it and say something had to be done to modify it. Right. So what was that modification? We had to certainly, first of all, start with a constitutional amendment, and the people approved that amendment by 62% this past November. And with that, although we had a bill passed last year, which was House Bill 808, to begin, let's say, the talking of the restructuring of the JQC, a lot of things were happening within that bill toward the last day, 2 days of the session. I knew that that was not a final product, so I felt there would be something to be done if the constitutional amendment passed to really re-examine and go back into trying to restructure the JQC. Yesterday, the bill was filed and assigned to my committee as House Bill 126. If you wish to look it up, I brought a copy today for my own reference, I say. But we have worked, I have, with several people very diligently, including Justice Namias, who had a ad hoc group to come together and really look at some things that they felt had to be done from the rule side of it, because the rules that were implemented in operation of the JQC had not been changed since 1974 when it was first set up. And even though it had rules, one of the things that we found a problem with the JQC, they would not operate within their own rules. So we had that as a factor. So Justice Namias had a group that helped work on rules, and he and I have had numerous conversations, as have with other people, about what do we want to do as far as the restructuring of JQC. It probably had, I felt, more fairness within the existing JQC, and I say by fairness, so often we heard of citizens who filed complaints with the JQC and would never hear what happened to my complaint. Is it going forward? Is it stopped? Has it been decided not valid or whatever? So one of the things that we recognize, this is being really addressed with the rules, but people, when they file a complaint, as citizens Certainly, a lot of the complaints that were filed are disgruntled litigants who felt the case that the way it came out wasn't what they expected, and so they're mad at somebody, and oftentimes it's a judge who had to make decisions. Was the judge making those decisions within the guidelines of law was a question. Realize that the JQC is looking at the oversight of judges through the standards of what we call judicial conduct that is adopted by our state Supreme Court, the canons of judicial conduct. And that is the real guiding principles of that, as well as the advisory opinions that are approved and adopted through the JQC and the Supreme Court. So there has to be those parameters to recognize that there's a complaint that has merit to go forward. It's not what the judge does making error, I would say, as far as applying the law. That happens. That's why we have the appellate courts. The appellate courts address that type of issue. So first of all was the issue of fairness. We felt there had to be an opportunity for whoever files a complaint to get information back, what was going on with their complaint. Secondly is due process. The JQC, as we had set it up under the Constitution, lacked really due process. What I mean by that is we had 7 commission members, and these commission members were the ones who received the complaint, they reviewed the complaint, they did the investigation of the complaint, and then once they determined something wrong has gone on, they were the judge and jury of the complaint and the sentencing judge. So there was a lack of what I consider to be appropriate due process in the way that it was structured under the Constitution, and it couldn't be changed. That was the problem about it. It was embedded in the Constitution, and there was no way anyone could change it. So you had to have, first of all, a constitutional amendment as a means of opening that up and begin dealing with the issue, first of all, of due process. We have done that. The bill that I mentioned to you, House Bill 126, is going to have 2 different panels. We're going to maintain the 7-member commission as the investigative panel. And that is a panel that will go through the process of receiving complaints, reviewing complaints, determining if there's something that may be further in need of investigation, and go through the further steps of investigation, as well as dealing with a judge who may be in error on something he's done as far as, or she has done, as far as her conduct, and determine if there's to be meted out some type of agreement for disciplinary action. That action can be from something as a admonishment, a letter in the file, or whatever, all the way up to removal from the bench. Now, if the judge disagrees, and there's now to be a hearing because the judge says, I don't accept what you're trying to impose on me, there will be a separate panel. And that panel will consist of 3 members. And those 3 members will be made up of a judge and an attorney appointed by the Supreme Court and a layperson appointed by the governor. My initial plan was to have all 3 of them appointed by the Supreme Court, but the Supreme Court said we really don't want to deal with lay people, so we decided to use the governor for that purpose. So what we'll have now, to go through a little bit of the process, you're going to have the appointment of 7 members, and those 7 members will be made up of the judge appointed by the Supreme Court, 3 attorneys, 1 appointed by the Speaker, 1 appointed by the Lieutenant Governor, 1 appointed by the Governor, 2 lay people, 1 appointed by the Speaker and 1 by the Lieutenant Governor. So there'll be 7 members on the panel, which we call the investigative panel. Then you'll have the Supreme Court appointing the 2 I mentioned, and the Governor, and that is the hearing panel. So we've got a diversity of appointments in place. So we think we've addressed really the issue of due process. The big thing that I'm sure this group is interested in is transparency. And we have done a lot of things that you'll read in here that address transparency. Yes, we do maintain confidentiality of what is going on with the filing of the complaint, the review of the complaint, the did pretty much away with the past, but you did not have the openness as far as if a judge and the JQC entered into some type of settlement agreement, knowledge of that. We think that is something that's public, just like you and I as lawyers. We get it published, and either we accept it, it's on our bar record from then on. So we felt the same thing should be applicable to.
For the record, we're both clear.
We're clear to tell you. Clear to tell you, that's right. But that is the transparency part of it. And I'll from that stop, and
Okay.
I'll make a little discussion, but that's the three main issues we're trying to address.
And we'll come back to this subject in Q&A.
Yes, sir.
Move along, but before we did that, I did want to ask one question on the transparency. If it's been decided, I think under the current rules, if someone makes a complaint about a judge to the JQC takes the position that it's illegal and improper for that person to even disclose to anybody that they've made that complaint or what it's about. Is that still going to be the case?
There's nothing in the bill about that. Now, whether they do something in the rulemaking process on it, I don't know, Peter. I will add one last point.
Sure.
In the past, the JQC of old took the position that everything they did was confidential. But there was nothing open as far as even their meetings, their administrative part of the meetings. And so we addressed that with saying, no, the only thing's confidential is what you're doing with regards to the complaints